Last Thursday, October 23rd, a really important decision came down from the First Circuit Court of Appeals, the federal appellate court that covers Boston and Massachusetts, in a case brought by Stand With Us against MIT, the Massachusetts Institute of Technology, the University in Boston. Stand With Us is a group that was founded in the early 2000s to defend the state of Israel, to educate students around Zionism, and to gain allegiance among Jewish students around the Zionist project and around the state of Israel's policies. So Stand With Us has sued a number of universities since October 7th of 2023, including Columbia, but other universities, including MIT, claiming that the university's response to the student protests against the Israeli government's military campaign, shall we call it, in Gaza, created a hostile environment for Jewish students on campus, a violation of Title VI, the federal law that prohibits discrimination or the creation of a hostile environment for Jewish students in education. So this decision in the MIT case is incredible. It's incredible, and I want to just highlight a few of the things. So among the things that the court found is that the students' protests, this is pro-Palestinian students' protest and speech, did not violate Title VI. That is the federal law. Why is that the case? So the argument was because there were students who were critics of Zionism, of the project of political Zionism in Israel, that was itself anti-Semitic. Any criticism of Zionism is anti-Semitic. The court said absolutely not. There is a big disagreement, a difference of opinion among scholars, among political theorists, among politicians in Israel, among Jews elsewhere in the world, around whether Zionism discriminates against non-Jews and what that project in Israel means. Universities are supposed to be bastions for free speech and disagreement, and so the court rejected the idea that a criticism of Zionism is itself anti-Semitic. So too, the court said, the phrase "from the river to the sea" is not itself anti-Semitic. Now, it could be used in an anti-Semitic way, to be sure, but it wasn't. There was no evidence of that necessarily in the MIT case. The court also held that the political project the protesters had of singling out Israel for its policies relative to the Palestinians after October 7th didn't mean that they were anti-Semitic, those students, because they weren't also calling out Burma, Sudan, China. You know, we can come up with a lot of countries that are engaging in human rights violations right now. And as the court said, it's not an unusual thing to focus on one political project, and you don't have to focus on every political project in order to combat the claim that you're being discriminatory against the one state that you have a criticism of. Now, what's important about these three findings by the court in Boston is that these claims meet the definition of anti-Semitism advanced by a group called the International Holocaust Remembrance Alliance, IHRA. So the IHRA definition of anti-Semitism, which has been pushed for a long time and was largely viewed as unreasonable and as censoring free speech in a lot of contexts, it included this idea that if you only call out Israel, then you're being anti-Semitic because you're holding Jews to a different level of account, or the state of Israel to a different level of account than other countries. That criticisms of Zionism are essentially anti-Semitic because the Jewish people identify so much with the Zionist project. So it goes to the core of what it means to be Jewish. And that phrases like "from the river to the sea," even though there are members of the Israeli Knesset who are right-wing Zionists, use that term because they see the entire area of what they call Judea and Samaria as belonging to the Jews. You know, they say that, so do Palestinians, and for lots of complicated reasons, many people say it. The IHRA definition claims that it is essentially anti-Semitic when said by the supporters of Palestine. So this view of anti-Semitism, the IHRA definition of anti-Semitism, was fully wholly and absolutely repudiated by the court in this MIT case on the grounds of free speech and open debate. Columbia University, a few months ago, adopted the IHRA definition of anti-Semitism. Other universities have done as well. And it's my hope that Columbia, its general counsel, its advisors, its board of trustees, as well as those of other universities, will look to this First Circuit case and maybe learn something about the meaning of this kind of speech, particularly in an academic environment, and that it's not essentially and always anti-Semitic. It can be, but you'd need some facts to show reasons why the speech in a particular case was anti-Semitic. So too, the court said the encampments, they had encampments at MIT just like at Columbia, did not create a hostile environment for Jewish students. There weren't particularly anti-Semitic things said by the students who were engaging in the encampment. These kinds of protests have a long tradition on our campuses. They're not in and of themselves anti-Semitic, and these are the sorts of things students do. Now, they might be subject to other disciplinary punishment at a university for interrupting classes and doing things like that, but not anti-Semitism. So the court found that as well. So too, the court said that arguing that what went on in Gaza, or what has been going on in Gaza, is a genocide is not necessarily anti-Semitic. And the court said this is an easy one to get rid of because there are Jews in Israel, political scientists, human rights activists, members of the Knesset, who have also said that Israel's policies in Gaza amount to a genocide. So there's reasonable disagreement among experts and activists around that question. So what we should take away from this important decision, it's well written, it's well reasoned. There was 3 judges, all of them agreeing, there was no dissent, is that the kinds of policies that have been adopted at Columbia University, the kinds of policies that have been urged by groups like Stand With Us, should be repudiated in an academic environment. That they have taken an overly broad approach to anti-Semitism while recognizing that there are real instances of anti-Semitism. To claim it so broadly in these contexts is unreasonable and undermines the academic mission of our universities. It's worth a read. I'll put a link in below for you to read the opinion itself. It's beautifully written, it's well thought through, and we'll see what kind of impact it has outside of the MIT context. It's to be expected that Stand With Us will appeal to a larger panel of the First Circuit, and it may eventually go to the Supreme Court, but for right now, this was a slam dunk win, and it was a win for academic freedom, for free speech, and for our ability to talk about hard things that we may not all agree about. But they're not all hateful when we disagree about them.